Lorna Woods, professor of Internet Law, University of Essex background. The case of Bărbulescu concerned the extent to which employers could track employee communications, including Internet use, when those communications might include private correspondence rather than business communications. Here, an employer dismissed an employee for failing to respect a prohibition on the use by employees of work equipment for private reasons. The employee sued his employer in the Romanian courts but lost, so brought a claim under Article 8 ECHI, which protects the right to private and family life, home and correspondence. In particular, Bărbulescu objected to the fact that, to find that he had violated the policy, his employer monitored his communications. This, he claimed, was contrary to the jurisprudence of the European Court of Human Rights in Copeland v UK. The fourth section of the Strasbourg court held, at the beginning of 2016, that the legal situation in Romania did not give rise to a violation of Article 8. While the media tended to summarize the position as the court permitting entirely unrestricted monitoring, this was not entirely the position as noted by Steve Pears here. The matter was in any event referred to the Chamber, and it is with this judgment that this note is concerned. The Chamber came, albeit not unanimously, to the opposite conclusion from the fourth section, finding that there had been a violation of Article 8 ECHI. So, why has it come to this conclusion? Judgment. The Chamber first considered the applicability of Article 8 to the situation in issue, reiterating a long list of previous cases. It emphasized that Article 8 should not be understood narrowly and includes both the right to develop relationships with others and professional activities or activities taking place in a public context. The court noted two further separate points. First, it commented that restrictions on an individual's professional life may fall within Article 8 where they have repercussions on the manner in which he or she constructs his or her social identity by developing relationships with others. Para 71. In this context, work is important in providing the possibility for individuals to develop relationships with others. Secondly, while life in the list of interests protected by Article 8 is qualified by the adjective private, the term correspondence is not so limited. Para 72. The court noted that while the test of a reasonable expectation of privacy has been used to determine the scope of Article 8, it here reiterated that is a significant, though not necessarily conclusive, factor. Para 73. The court concluded that, while the employee was aware of the ban, he was not aware of the monitoring, that some of the content was intimate in nature, that he alone had the password to the account. The court left open the question of whether Bărbulescu had a reasonable expectation of privacy in the light of the employer's policy, of which Bărbulescu was aware, but then held that an employer's instructions cannot reduce private social life in the workplace to zero. Respect for private life and for the privacy of correspondence continues to exist. Para 80. Both the right to private life and the right in relation to correspondence were therefore engaged. The court then considered whether there had been a violation. In this, the court was faced with the question of whether there was a positive obligation, given that the employer was not a public body. The court noted that the monitoring of the communications could not be regarded as interference with Bărbulescu's right by a state authority. Para 109. Nonetheless, the measure taken by the employer was accepted by the national courts, thus engaging the state's positive obligations. Para 110,111. It restated that the test was that of whether a fair balance had been struck between the competing interests. The court noted that labor law has specific characteristics which allows for a wide margin of appreciation. This is not, however, unlimited. States must ensure that there are safeguards in respect of the monitoring of communications. It identified a number of issues: clear advance notification of the possibility of monitoring, the extent of the monitoring and the degree of intrusion, taking into account the difference between monitoring flow of communications and the content, the justification for the monitoring where the less intrusive mechanisms for monitoring exist, the consequences for the employee whether adequate safeguards were in place. Further, there should be the possibility of a domestic remedy. The Chamber took the view that the domestic courts did not consider or did not give appropriate weight to all the issues identified. Para 140. Notably, it did not appear the employer had given Bărbulescu sufficient advance notice of the extent and nature of its monitoring activities, or of the possibility that it might have access to the actual content of his messages. The court was also skeptical of the national court's acceptance of the justification for the intrusion. There was therefore a violation of Article 8. There was dissent, however, on the assessment of the National Court's approach to the matter. Comment: the headline news from this is that the Chamber came to a different determination on the issue of breach from the fourth section. It should be noted, however, that even the Chamber did not suggest that unlimited monitoring would be permissible, c.e.g. Steve Pear's analysis. Nonetheless, in purely practical terms, the Chamber judgment provides a clear statement that workplace privacy cannot be reduced to zero, as well as a list of considerations that will be useful not just for national courts but also employers in considering policies regarding personal communications in the workplace. Note that this case concerned a private employer, not, as in Halford and Copeland, a public body as employer, so the considerations highlighted will be of relevance to all employment relationships. In this, the Chamber seemed to respond to some of the concerns expressed by Judge Pinto de Albuquerque in his dissent from the fourth section judgment regarding the factual specificity of the case. The judgment also seems to recognize the importance of work as part of daily life, an important point given the blurring of boundaries in the always-on culture of smart devices in which work-related information and communications cohabit with those of life outside work. There are some further points to consider. The first is the scope of Article 8 and in particular the reasonable expectation of privacy. Article 8 lists a number of aspects: protected private and family life, usually seen as two separate elements: private life and family life, home and correspondence. As written, it seems that these are distinct elements, yet the reasoning of the court does not always treat them as separate. Arguably, the court's previous approach in making the matter one of a reasonable expectation of privacy blurs any boundaries between these elements and in so doing, limits the scope of protection as far as correspondence is concerned. The Chamber seemed alive, at least in some regards, to this point. It specified that there is no requirement that correspondence be private. If that is the case, however, why is the issue of reasonable expectation of privacy relevant? Indeed, the Chamber noted that the test of reasonable expectation of privacy is not the be-all and end-all of Article 8 c. para 78. Despite this recognition, the Chamber still turned the question into one of a reasonable expectation of privacy. It is open to question whether, and if so, to what extent, the employer's restrictive regulations left the applicant with a reasonable expectation of privacy. Para 80. Is the court here suggesting that correspondence is protected by Article 8 only when there is a reasonable expectation of privacy? Seemingly so, yet the Chamber continued to state, an employer's instructions cannot reduce private social life in the workplace to zero. Respect for private life and for the privacy of correspondence continues to exist, even if these may be restricted insofar as necessary. Para 80. The position is consequently somewhat unclear. It would be more straightforward were the court to recognize that correspondence constitutes a separate class aside from private life, however broadly understood, and to deal with scope of Article 8 as a separate issue from that of interference and justification. The current position unfortunately seems to be embedded in a long line of case law. Bărbulescu is distinct from previous case law on employee monitoring in that it involved the state's positive obligations. The court has tended to adopt a different approach in regard to positive obligations than negative obligations. Rather than look at Article 82 and the tests of legitimate objective, lawfulness and necessity in a democratic society, it adopts a fair balance test within which the state has a broad margin of appreciation. On this basis, the sidelining of the Copeland ruling, which fell at the lawfulness stage in a standard Article 82 analysis, is understandable. The court seems to suggest, however, that there are parallels between positive and negative obligations in both contexts. Regard must be had in particular to the fair balance that has to be struck between the competing interests of the individual and of the community as a whole, subject in any event to the margin of appreciation enjoyed by the state. Para 112. It is questionable whether the derogation from an individual's rights by state actors really should be seen as being about a fair balance, a stance which arguably nudges the focus of protection away from human rights as paramount. Nonetheless, here the court brings in factors from the standard Article 82 state surveillance case law aimed at preventing abuse of secret surveillance capabilities to provide guidance in finding the fair balance. It is noticeable that Copeland is not considered but instead the state surveillance cases of Klaas and Zakharov. It might be that the Chamber accepted the referral because it wished to deal with failure of the fourth section to consider the EU Data Protection Directive, which protects against the collection of personal data without the explicit consent of an individual or justified grounds for such collection. This point was highlighted by Judge Pinto de Albuquerque. If so, the judgment fails to engage with EU data protection law in any meaningful way. The Chamber noted that the national courts had considered the directive, but did not consider those rules themselves. Insofar as the court does refer to international and European standards, it specifies the ILO standards and Council of Europe recommendation CMREC 20155, rather than the directive. It seems then that there has not been any direct engagement with the substantive EU data protection rules. Photo. Credited and Burles LLP.